Any mention?
May I please, Your Lordship? I beg to mention item 9 and 10, Your Lordship. The conducting counsel, Mr. Pathak, is not available, Your Lordship. I'm praying for 2 weeks' time.
No objection, Your Lordship.
On pre-made by the petitioner, this is matter of 2 weeks.
9 and 10, Your Lordship.
2022 matter.
Yes, Your Lordship.
What's the matter about?
Your Lordship, it's a pension matter, Your Lordship. Yes, Your Lordship. He was dismissed from service, but pension was not granted, Lordship. Okay. Oblige, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 11, Your Lordship. In this matter, I am supposed to file an application and objection to the inquiry report, the plea of juvenility, my Lord. This is a criminal appeal against the POCSO, my Lord.
You are?
I am for the appellant, my Lord.
Appellant?
Yes, item number 11 of the daily costless, my Lord.
Plea of juvenility, who has?
I have filed, during the pendency of the appeal, my Lord, I have filed an application for a plea of juvenility, which was remanded back to the learned trial court, my Lord, for the inquiry. And the inquiry is there before Your Lordships, my Lord, is in the file itself. And then after I was directed to file a paper book also, which I have filed, my Lord. And in the previous hearing, my Lord has asked me to file an application in regards to the plea of juvenility, my Lord, because the report is against me. The report is that I am not the juvenile. The appellant is not the juvenile. Yes, my Lord. So further, my Lord, I seek another 1 week's time, my Lord. I'm already prepared. Just the signature of the appellant is left, my Lord, for filing.
Oh, you see, once the plea of juvenility has been decided by the trial court.
Yes, my Lord.
So matter is, you see, it goes back to square one. So the conviction has to be challenged and matter to be heard on merits.
Yes, my Lord.
Then nothing is left as far as juvenility is concerned.
Yes.
Lordship, can we have the order dated 24/9/25 passed in the criminal appeal? (24/9), Your Lordship.
24/9. Oh,
That application is yet to be filed, Your Lordship.
okay. So you're challenging the findings in the
Yes, my Lord. Yes, my Lord.
inquiry. On pre-made by Miss Learned Legal Aid Counsel, this is matter after
It will be 2 weeks, Your Lordship.
It will be 2
2
weeks, my
weeks.
Lord.
2 weeks.
Highly obliged, my Lord.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 4, my Lord. I'm praying if this matter will be taken up after a week.
Come.
Union of India.
After
Union of India is the main.
It's a very long pending matter, my Lord. Unnecessary delay.
next week, my Lord.
So you want to give them relief?
But this is travel to all the courts, my Lord. This matter.
Not all.
On pre-made by the
Except Chief's Court.
petitioner, this is matter after 1 week?
1 week.
1 week.
You take 2-3 weeks. You were,
No, next week, my Lord. After a week.
I'm
After a
saying if
week,
you're
my Lord.
not ready, take 2-3 longer date.
My Lord, after a week, my Lord.
Okay.
On supplementary list, item number 1.
Yes, who's appearing for state? Mr. Shulai?
The brief believe I'm not aware which.
Mr. Silla appeared
I
yesterday.
think, Senior G is there, Your Lordship.
Who is she?
My apologies, Your Lordship.
This is a revision, my lord, against cancellation of anticipatory bail by the trial court, my lord. My lord, before, my lord, at the outset, I'll submit this is something like a mercy petition only before Lordship, my lord. Because here, what happened, my lord, against this particular person, there are 7 or 8 FIRs filed, my lord, already, all over Meghalaya, my lord, from Garo Hills to Kanapada. But he was basically a dealing with liquor, my lord, retail liquor stores, and there was some kind of dispute with the bond owners, my lord. Primarily, I'll submit this in the
I recall this matter
Yeah,
because I've dealt with this matter for quite
number of times, my lord. Many times it will travel. My lord, in this particular case, this is the FIR from Khanapada, my lord. My lord, FIR was registered. We moved session court, my lord. Session court rejected the bail, my lord. We approached this honorable court, Your Lordship, because 3-4 matters were heard on the same day, my lord. In other matters, Your Lordship was pleased to grant anticipatory bail, my lord. But Lordship was pleased to reject in this particular Khanapada case, my lord. Now, against that, we went to Supreme Court, my lord. And I'll take Your Lordship to the page 34, my lord.
yes.
Now, the Honorable Supreme Court is pleased to grant anticipatory bail, my lord, by this order. Now, if I may just read to para 4, my lord, at page 35.
Yes.
Having heard the learned counsel for the appellant is also learned counsel for the respondent state, and having considered the matter placed on record, in our view, the appellant is entitled to the relief of anticipatory bail. We confirm the order passed by this court and direct that the appellant be given the relief of anticipatory bail. In the event the appellant is arrested, he shall be released on bail on such terms and conditions as may be determined by the concerned court. Needless to say that the appellant shall fully cooperate with the investigation. In case the appellant does not cooperate with the investigation, respondent state is at liberty to move the trial court for cancellation of his anticipatory bail. Now, this is where the liberty was given, my lord. And against this, on the ground of this liberty, my lord, an application was filed by the IO before the trial court. That Your Lordship will find at page 39, my lord.
Yes.
So, my lord, when we received notice of this miss case, my lord, for cancellation of bail, the trial court directed us to be present on court, my lord, on the date. Page 83 is the first order, my lord.
No, just first, you tell me, after you have received the order from the Supreme Court,
My lord.
then you naturally have to approach the trial court.
But here what happened, my lord?
Or the conditions to be set up, yes, to be set out.
But there is no such direction. Direction was only to cooperate with the investigation.
Court,
in the event of arrest.
In the event of arrest, my lord.
or in the event of arrest.
My lord.
No, exactly. So after this order has been passed, you have not been arrested.
No, my lord. This was order passed on 29th of April 25, my lord. This April order, on the 29th of April, end of April, my lord. Thereafter, they filed that application for cancellation of bail that was filed.
Cancellation of bill of what? Yeah, in connection with this case.
Yes, my lord.
When you were not arrested, how can bail be cancelled? Because you were given anticipatory bail.
My lord.
Anticipatory bail means in anticipation of of arrest,
Arrest, my lord.
then bail will be granted.
My lord.
I mean that is the norm.
My lord.
So now you say that you have not been arrested. If you have not been arrested, conditions would not have been set out. Could not have been.
My lord.
So now after that, why would they come for?
IO files an application for cancellation of bail.
Why would they come for cancellation of bail?
But that is the case, my lord. There was no bail as such granted by the court, my lord.
True. And cancellation of bail on what ground?
They say, my lord,
some violation of conditions.
non-cooperation, my lord.
Okay. So para 5.
My lord.
You have to cooperate with the investigation. You see, if you suppose, let's say, you are not cooperating with the investigation, then you will be arrested.
Yes.
Question of cancellation of bail does not come.
Here what the trial court has done, my lord, they moved, we entered appearance, my lord, after receiving notice from the court. Court directed for appearance on a certain date, that was 22nd 9. Now, my lord, we filed an application on that day before the trial court that he was indisposed, my lord, really bad health. He's a 63 plus, my lord, he's suffering from cardiac problems, BP related problems, my lord, and diabetes related problems. And we requested to dispense with personal appearance on that particular day, but the trial court rejected, cancelled the bail, my lord. I'll just take a lordship to the interim order, the order passed to the trial court.
Okay.
Page 160, I'll just read the operative part, my lord. Para 17.
Page
116.
para
17.
17.
This court, upon careful perusal of the so-called filed by the respondent, finds that the respondent could not provide any sufficient cause or even a whisper that they have responded to the notices issued by the petitioners. Learned PP vehemently argued that the petitioner is unable to interrogate the respondents and to verify the actual facts of the case due to evading tactics of the respondent by keeping themselves away from the petitioner. The petitioner is before this court only on the grounds of non-cooperation of the respondent. The respondents in their so-cause has attached the medical report claiming that could not travel to Nongpo, Meghalaya, and prayed that they are willing to appear before this court virtually. However, this court has noted the respondents, while filing their so-cause, have signed the affidavit in Shillong, Meghalaya. This clearly shows that the respondents have abused the concession of anticipated bail granted by the Honorable Supreme Court, and they have never appeared before the petitioner for interrogation. Considering the conduct of the respondent, this court is of the view that the respondents are willingly and deliberately evading appearance before the petitioner for interrogation. As such, the prayer of the petitioner for cancellation of bail is hereby allowed, and the anticipated bail granted by the Honorable Supreme Court is either hereby cancelled, and the respondents are directed to surrender before the court on or before the petitioner within a period of 1 week. And this is order passed on 6th October. So, my lord, the petitioner was suffering from ill health, my lord, and filing for cancellation of bail when the bail was granted only in the month of May, my lord, by the Supreme Court, and immediately the grounds of cancellation of bail, my lord. My lord, what is praying at this stage, my lord? Your lordship, there is no problem, my lord, in going and appearing before the court or before the IO, my lord. But only because he has 7-8 FIRs against him, my lord. Your lordship, on last occasion also recollect, when he came to appear before the Khanapada police station, my lord, he was picked up from there, taken to Garo Hills, my lord. One POXO case on that day, FIR was filed against him, then arrested in that POXO case, my lord. This is the case, my lord. My lord, the court also should appreciate all these facts, my lord, and considering his bad health, my lord, could have allowed him to appear virtually, or it's only a question of interrogation.
is there a provision for virtual questioning?
It is done, my lord. Number of occasions.
Okay. As you see, if he is to be questioned by the IO, then perhaps he may be referred to some documents, certain signatures, certain facts, figures. Then that could not have been done virtually. So he
In 1 week's time. Lots of grants. 1 week time we'll go and appear. There's nothing. It's not that we don't want to appear.
Another point, Dr. Muzika, this impugn order, I believe it is in the nature of an interlocutory order or an intermediate order. This is not a final order.
It is a final order. The anticipated bail has been cancelled finally.
There are conditions.
In the you see, in the context of the whole process, see, you know very well, a bail order is never final order. It's always interlocutory. That has been held in many.
Well, I can, because earlier also I moved for some NDPS bills cancellation. I moved your lordship recollect, my lord. I placed several decisions that cancellation of bail or a grant of bail is a revisable order.
You have those decisions too.
But I'm not. I didn't bring today, my lord. But I can satisfy that, my lord. Eventually, lordship rejected my application for cancellation of bail on the ground of on merit, my lord.
You have to look in the context of section 397, of course, earlier.
Yes, my lord.
397(2).
Yes. There are reasons, but today I didn't anticipate this question. My lord, today what I pray, my lord, if lordship fixes immediately after Diwali, my lord, this matter, giving us some interim protection, my lord.
I have objections, my lord.
For a week's time. For a week's time. In the meantime, he'll go and appear before the IO, my lord, and then the matter can be taken. By and large, this is civil dispute.
It is only, you see, if he has, let's put it this way, compelled himself to appear before the IO, that would serve your purpose. What do you want? You want him to be questioned. Now he has come before this court with a prayer that he will appear before the IO, and that would serve the purpose, like I said.
Yes, ma'am.
Because, my lord, if can you come to the
We
order of the...
will not go into the aspect of his conduct, previous conduct. You're saying about bail condition. Where are the bail conditions?
Because, my lord, can you come to the copy of the petition, my lord, page number 35, my lord, order of the Supreme Court, para number 5, my lord.
Yes. That has been pointed out. He has to cooperate, no doubt, but he has cited his reasons.
Because there's also, my lord, I'd like to place one order, my lord, same matter only, which has, your lordship has passed the order, if I may place, my lord.
Para?
My lord, this para number 20, my lord. Since they are citing that due to ill health and for that reason, my lord, you were unable to appear. Okay, my lord, can you come to para 20, my lord? If I may read, my lord.
Please.
None of the above steps have been taken by the respondent, and the only reason given is that he is having medical problem which has prevented him from appearing before the IO. However, this assertion has been proved otherwise, inasmuch as by his own admission on 16/02/2025 he has appeared before the Khanapara Police Station, Riboy District, in connection with Khanapara PS so-and-so, for which he was then brought to Tora West Hills in connection with Tora Women PS case number so-and-so, and again being arrested in connection with another case being Ampati PS so-and-so. And my lord, para 21, my lord, if I may read. Under such circumstances, the respondent could not have taken the ground of sickness perpetually to avoid appearing before the IO in connection with the case for which he was granted anticipatory bail. The conduct of the respondent has clearly exhibited a clear mindset of defense in complying with the aforesaid bail conditions. He could not take shelter in the case of Manish Goyal, as at para 16 of said case. The Honorable High Court of Delhi has noted that the accused therein has appeared before the authorities on various occasions, except for 1 or 2 dates, which is not the case herein. Therefore, being convinced that there is an attempt by the respondent to scuttle the process of the judicial administration by trying to avoid compliance of the directions of this court, the act of the respondent can only be seen as one of deliberate failure to abide by the aforesaid bail conditions. Para number 24. Accordingly, even while acknowledging the authorities cited by the learned GA, this court is convinced that the state has made out a case for cancellation of bail granted white order so and so. The same is hereby done so. On the said bail being cancelled, the IO is directed to take steps accordingly. So even on last occasion, they had suppressed the facts.
There are two facts. I'll just reply to that. That was February event, my lord. Here the Supreme Court bail is of 29th of April, my lord. So 3 months, more than 3 months passed away. Secondly, my lord, against that order also we have gone to Supreme Court has granted bail, my lord.
With the conditions, my lord, that in spite of that, they are still...
Against the order cited by my friend, we have gone to Supreme Court, my lord. Supreme Court has granted interim protection. So order 26/9/25.
You've been given interim relief, but matter has not been heard.
After that, it's not been. What is it like? Notice has been issued. Notice has been issued. State has filed affidavit. But some protection like this only, my lord. We will go and appear. We have no problem, my lord. By the returnable date, we will go and appear for the IO, my lord. Till then, he's an old person, my lord. He's a very sick person. And all the allegations of 2014, my lord. Now they have. If I'll take a lordship to the FIR also. All this bonded warehouse and retail, the business started in 2014, severed ties many years back. Now they got up somehow, my lord, and filed FIRs in every district of Meghalaya, my lord.
And then the case is very serious, my lord. They are evading tax and all, very serious in nature.
Who is evading tax, my lord? So that, of course, police will investigate whether we are evading tax or somebody else is.
Prima facie is well established, my lord. Even in the order of the trial court.
You have been, you see, if I'm not mistaken, you have been accused, forget about evasion of tax, of embezzlement.
There's no allegation of embezzlement. My lord, kindly see, I'll just take a lordship to the FIR, my lord. May I read to the FIR? The first para will indicate, my lord. So and so, as my manager to look after the affairs of the warehouse under his control since February 2016 till June 2024.
But in Musical Council, Senior Council, appearing for the petitioner, also heard Mr. Jain Kanja, G, appearing for the state respondent. It is the submission of the learned Senior Council that the petitioner as one of the appellant, he's the only one who has approached the Supreme Court.
Two, my lord. Father and son both.
As one of the appellant. Here is petition for both.
Both, my lord. Father and son.
The appellant kunung to that petitioners as appellants has approached the Honorable Supreme Court and by order dated 29 April 2025 passed in SLP under bracket criminal number 3588 of 2025. The Honorable Supreme Court in the operative part of the order has directed that the appellant be given the relief of anticipatory bail in the event, but here is all says he means only one person. The para 4.
But there are two separate. I have next only one.
You have not annexed that order.
You have not done it. There is a separate order for son also.
You should have.
Same date.
You should have.
Only SLP number here is 3588 value, that is 3615. I'll supply a copy. 3615.
Sa ko ka SLP number to and
3615.
another similar, identical and similar application being SLP criminal number 3615. Same order.
Same order.
Kung to the relief of anticipatory bail in the event they are arrested and shall be released on terms and conditions as may be determined by the concerned court. Next, it was also directed that the appellant shall fully cooperate with the investigation and if he does not cooperate with the investigation, the state is at liberty to move to trial court for cancellation of his anticipatory bail. Next. In due course, the IO, the investigating officer as petitioner, has approached the trial court, that is the court of the Learned District and Sessions Judge, Pigawai District, Nongpo, with an application under section 483 under bracket 3 BNSS with a prayer to cancel the anticipatory bail granted to them by the said order of the Honorable Supreme Court on the ground that they have misused the liberty granted to them and have failed to appear before the IO when called for. Upon hearing the parties, the learned trial court by order dated. Where is the impugn order?
Page 111, my lord.
Starting from 111.
Dated 6th of October.
By order dated 6/10/2025 has accordingly allowed the prayer meet and has cancelled the said anticipatory bail with a further direction to the petitioners herein to surrender before the court within a period of 1 week. The learned senior counsel has submitted that the petitioner number 1 is a person of about more than 63 years of age with various bodily ailments, and as such he was genuinely prevented from appearing before the IO when called for. However, though request was made for his appearance via video conferencing mode, or rather by online mode, the prayer was not allowed. It is the further submission of the learned senior counsel that it is not the intention of the petitioners to scuttle the process of investigation, but for the reasons so stated, and at this point of time they would give an undertaking that they are ready to appear before the IO on any date, at any place that they are directed to appear before such IO. Under such circumstances, it is prayed that the said impugn order dated 6/10/2025 be set aside and quashed, and the order passed by the Honorable Supreme Court be restored. Per contra, Mr. J.N. Ranja, the G, has strongly opposed the prayer meet, firstly on the ground that the offence alleged against the petitioners are very serious, even to the extent of an allegation made against them for tax evasion or the like, and secondly, their past conduct has consistently shown that they have no regards for due process and has flouted court orders from time to time. The non-appearance before the IO can also be construed as an act of defiance against the system. As such, the prayer made in this petition may not be allowed and the same be dismissed. Further submits the learned GA. This court has heard the prayer made, heard the argument made by the respective learned counsels for the parties. Facts as stated above would show that there has been an apparent violation of the Honorable Supreme Court's order by the petitioner when they have failed to appear before the IO as and when called for. However, nothing is seen, nothing is, however, no record is produced to show that the IO has made several attempts to compel them to appear before him.
My lord, sorry, my lord, to interrupt. My apologies, my lord. Actually, I have with me this report, my lord. I was about to give it later after the argument, my lord. If I can produce before my lord.
No, you tell me on this point.
So, my lord, they had received, my lord.
No, how many times have we called them to appear?
First time, like both the father and the son, my lord.
No, this was the first time.
Roger.
Exactly. Gunung Toko? Gunung atau pulih yang di last line ngomong apa? Except the one occasion, as has been pointed out by the petitioner and confirmed by the learned GA. It is well settled that in the matter of cancellation of bail, the courts has to be diligent and circumspective, since it involves the personal liberty of a citizen, and if not for very apparent or misconduct by the petitioner or a clear violation of set conditions imposed by the court, more often than not, the courts would be lenient. The courts and even the prosecution would be expected to take a lenient view if in the long run the objective would be solved by the conduct or appearance of such accused person or petitioners. So correct bhag tulta. In this case, since it was only on the first call that the petitioner has failed to appear for the IO, this court is of the opinion that opportunity must be given to the petitioner to appear for the IO if and when called for. Accordingly, the prayer made in this petition is hereby allowed. The impute order is set aside and quashed. In the next set aside and quashed, the petitioners are however directed to appear for the IO positively. Today is 16 by 18 by 18
after Diwali.
Then you appear tomorrow.
Because at 18th is Saturday again.
Then you appear tomorrow. Saturday, police station is always open, or Saturday is closed.
At us Diwali time.
They're getting too much leniency, my lord.
But 22nd, my lord. 18th and 22nd will not make any difference. Because the 2 days Diwali, my lord.
Then you appear tomorrow.
Because he has to come from Jaipur.
Either 18 or tomorrow. Tomorrow is 17.
But 22nd, well, kindly, man. The Lordship is given so much of indulgence. Only 3 days.
Exactly, that is exactly the point.
In spite of repeated violations, my lord.
Considering your prayer,
Don't add, there is only one violation. 22nd, well, kindly, my lord. Let him, or 21 also is okay, my lord.
You're taking
21, kindly, my lord. We have to book tickets also, he can travel all the way, my lord.
what is the stage of the case?
my lord. I'll have to get proper instructions, my lord. Actually, ma'am, and the Shila is
No, but no investigation not completed, charge sheet
on.
filed,
No, investigation is still going on.
charge sheet not filed.
No.
No, my lord.
Fine. Kung to go? On 22nd October, feeling which the report of this in which the IO would take necessary steps to bring them into custody. Bring them to custody. Petition disposal.
My lord, the son's Supreme Court order is also on record, my lord. I missed out that. Father's order anticipatory will granted by Supreme Court. I placed that, my lord, page 35. Son's also is on record, my lord, page 78. I just missed that out.
But you said the same order, isn't it?
Same order, my lord. The only case number is different, my lord. Here the date is also slightly different. This is 21/4/25, in case of son. Page 78. Order is same, my lord.
21/4. How to kumai kayo dated? Kano? Yung katuka
3615.
yung katuka 3615. Katuka SLP 3615. Ay ko orders yung katuka day 21/4/2025 ko. Petition is
From daily list, item number 1.
May please, Your Honor. Your Honor, this matter is fixed as an admission hearing. But Your Honor, in order in FA2, which is item number 3, Your Honor has passed an order that both the matters will be taken up together for hearing. So can we kindly
no, this matter has been appeal has been admitted, isn't it?
Appeal has not been admitted as yet.
Your Honor,
This appeal has not been admitted.
Your Honor, my lordship here, the order which is passed in FA2 or allowing my condonation of delay, this appeal has come for admission. But there is an order in FA2, white order dated 22/08/2025. If the order is, can you please order? (2208).
Yes, no. I think what the court intend is that since these two matters are correlated,
Yes.
It's on the same day.
so they emanates from the same impugn order, isn't it?
Lordship.
So
So, Lordship, here it is, as per the order, may be taken up for consideration jointly in this proceedings.
your appeal will be admitted and the matter will be heard.
Yes, Lordship.
No, I have objections towards the admission of the appeal, Lordship.
Oh, you have an issue
Yes, Lordship. I have objections.
on what ground?
Because no ground has been made out for an appeal, Lordship. Only ground given in the appeal.
You are respondent.
I'm respondent, Lordship. I'm the private respondent. 3 and 4. Only ground is that the award was not there before the reference court. So it has to be dismissed. The Deputy Commissioner, while forwarding the reference to the reference court, ought to have given the award, and the award was not given. Lordship, I'll just read the ground. Item number 50, page 55. Consider not furnished. For that, the Honorable Special Judge.
Just move.
Page 55, ground number 2. These are the ground number 2. For that, the learned Honorable Special Judge, Judicial Officer, has failed to appreciate that the judgment was passed without considering the award passed by the collector. The collector has not furnished a copy of the award along with the reference before the Honorable Court. 3. For the Honorable Special Judicial Officer has failed to appreciate the settled position of law which is required to be decide the reference made under Section 18 of the Land Acquisition Act. A copy of the award is mandated to be enclosed. Lordship, these are the primary reasons for which they say that the award, then again, ground 5, for the learned special judicial officer has not considered the fact that while passing the judgment and order, that a copy of the award was not forwarded to the Honorable Court. It is only in connection with the fact that the award was not forwarded. Now, Lordship, when a reference is made under Section 18, the Deputy Commissioner, the Collector has to give a statement under Section 19. And the particulars specified in Section 19, only those particulars have to be furnished. The copy of the award is really not necessary because that is basically the Deputy Commissioner taking certain views, objections, etc., does a clerical job of fixing the award. He applies his mind, no doubt, but it is the reference court which is the original court, which will look into everything. Its reference court is not an appellate court, it's the original court which will look into the evidence, everything. Both the parties will be allowed to give their evidence, and on the basis of the evidence given, the reference court will decide. Now, under Section 19, Lordship, what is to be forwarded? Collector's statement to the court. In making the reference to the reference, a collector shall state in Lordship 19.1. In making the reference, the collector shall state for the information of the court in writing under his hand A. The situation and the extent of the land with particulars of such tree, any trees, buildings standing thereon, crops, etc. thereon, name of the person whom he has reasons to think is interest in such land, the amount of award for damages and paid or tendered under Section 5 and 17 or either of them, and the amount of compensation awarded under Section 11. The amount paid or deposited under subsection 3A of Section 17, and if the objections be to the amount of compensation, the grounds on which the amount of compensation has been determined. To the said statement, there shall be attached a schedule giving the particulars of the notice served upon of the statement in writing made or delivered by and the particulars of the interested and the parties interested respectively. This is all. There's no question of furnishing the award. The award by the Deputy Commissioner basically is a calculation based on his premises. It's in the reference court itself that the question of evidence will come in, the actual decision will be made. Just the ground that this reference may be bad for other reasons, Lordship. Even I have come before your Lordship because the reference is not good. She may have a point that the reference is bad, but not because the award was not furnished. That is incorrect. So this, basically on that ground, this appeal does not merit admission. But whereas as far as the reference court is concerned, my respectful submission both in this and the second item, FA2, my submission is that the reference court, not having considered all the materials, in fact, the materials were not before because my evidence was not considered. The other side, the collector did not give his evidence. There was no evidence, nothing. So that order is based without evidence. So the entire matter should go back to the reference court. That is my submission, and let the reference be decided afresh with both all the interest parties giving their evidence substantiating their claim, and the matter can be decided. This is my submission. What is it that the matter should go back to the reference court? Because the lordship sitting in appeal will not decide what is the value of this plot, what is the value of this structure, or what is that. Lordship will not go into that. It is only.
But as a first appellate court, the evidence has to be reappreciated or can be reappreciated.
Yes, but my evidence is there, but the other side has no evidence. So if the lordship decides on the basis of my evidence, I have no problem.
Whatever the case may be, whatever the case be,
my evidence is there. I have given my evidence about the land value, which has not been refuted. I have given evidence about the business laws, which has not been refuted. So on the basis of that, lordship can decide.
And that's beside the point. You are going to the other.
But this appeal does not merit admission. Because on this count, the award is not there. That cannot be the ground. He is not mandated to pass the award, give the award. Award I asked by the matter of fact. Even she never asked for the award. I asked because I didn't know the award at all. The award was not before us. We were denied of the award right from the beginning. But to say that the reference is bad because the award was not there, that is incorrect, Lordship. On that ground, no appeal can be admitted.
Yes, Miss, what do you have to say?
Lordship, today the matter is just fixed for admission hearing, Lordship. And unless the matter is admitted, Lordship, and we proceed further hearing, why the award is at all mandated? Because, Lordship, the award contains not only section 19, but it also should contain section 23 also. So, Lordship, I have some judgments which shows that, but since we are not in the final hearing,
no, we are only on the
admitted
admission
position. So
you have to convince this court that your appeal can or has to be admitted,
Lordship,
in the face of the challenge on maintainability by the respondent.
Lordship.
So, Madam has has given her submission on the objections as far as maintainability is. I mean, as far as your appeal is concerned.
Lordship.
So now you have to convince this court that yes, this appeal has merits. It need to be decided. Need to be heard and decided. That is what you have to convince this court.
Lordship, the section 19, what my learned senior has already mentioned, the reference court has to make the collector's statement has to be there, Lordship. Lordship, along with the collector's statements, why award is very much important, Lordship. Along with the collector's statement, the collector has to also state through award section 23 also, Lordship. Section 23 of the Land Acquisition Act, the collector has to apprise the trial court wherein it has been already mentioned, section 23, Lordship. May I, Lordship?
What you have to, you see, in fact, both of you has, even the collector for that matter, you have to come up with precedent to say that in every case of this kind, whenever there's an appeal, it is not incumbent or not necessary for the copy of the award to be part of the reference court proceedings. Is it so? That's what you're saying.
Yes, this statement under 19, that is what is mandated.
True, it may be the provision, but this I'm not so clear what is provision.
Only that is mandated.
See, yes, I'm not so clear that it did not specifically say that the copy of the award is not necessary to be incorporated. It doesn't say that.
It will be reading something which is not there.
So it can be construed the other way around also.
Lordship.
But that's reading a little more, Lordship.
That's why I said if there's no specific provision, then you have to go by precedent.
Because when the Deputy Commissioner...
Yes, Mr. Sen, what do you have to say? You should be well versed with this matter.
The language of section 19 does not admit to such a position where a copy of the award has to be attached.
No.
That's number one. Number two, my lords will have page 55 of the memo of appeal. One of the grounds. because I in fact called, telephonically called my friend to inquire whether there is any precedent, because section 18 may have been interpreted by some superior court where they may have said that the award is crucial. This is what they've said in para 3, the third ground. For the Honorable Special Judicial Officer has failed to appreciate the settled position of law which is required to decide the reference under section 18 of the LA Act. The copy of the award is mandated to be enclosed along with the reference. So I had inquired whether there is any such decision of any superior court. So we could at least examine it and see whether there is any consequence provided in case the award is not attached. I am not aware of, I have done my research, I have not come across any such judgment which has interpreted section 19 in that fashion.
Exactly.
Even section 88 talks about the powers under section 18.
So subsection 2 of section 19 only talks about a statement, the schedule which is to be appended, nothing more than that.
Because the award comes with a record. When the Deputy Commissioner sends a record, which he has to send, the award comes with that.
True. True. But why? You see, but why would the reference court be,
interested in the award?
Be ignorant of that?
Usually what happens after a reference is made, although again this is something not provided in the Act statutorily, the claimant files a claim application. In that claim application, they list out all the annexures, including the award. Now, in this case, strangely enough, the appellant, the respondent here today, had argued on an earlier occasion that they were not aware of the factum of the award. There is no.
No, we didn't have a copy of the award.
Okay, this is something which is not borne out of record in their pleadings or anywhere else. So I think that is the reason why this whole can of worms was opened and how the Nahai decided to file this appeal.
Exactly.
So this statement was made in the course of my learned senior's argument that the entire process is bad because of non-furnishing of the award, along with the statement in the section 19. That's how this whole thing is opened up. Now, when my learned friend for Nahai says that this is a settled position of law, I am presuming there is a judgment of some superior.
Exactly.
So I would like to examine and see whether there is any consequence provided.
So where are your authorities?
Lordship, today I did not carry because as per the Lordship, the previous orders which I have read out, Lordship, prior, I was under impression that the matter is already admitted. It is because Lordship has already stated that the matter is taken up for consideration jointly in these proceedings. Lordship. So Lordship, I was under impression the matter has been admitted and we are on final hearing, Lordship.
When the matter is clearly listed for admission, nothing is said that it is listed for hearing.
Lordship.
You check on the precedents and come back.
Lordship.
When do we take it up?
At first, Lordship convenience.
This 23rd, the other set of appeals are fixed.
Lordship.
On?
23rd.
Next week.
So we'll take it up on 23rd?
Huh?
23rd?
23rd is a...
Same issue.
Same issue, Lordship.
23rd is a... we have a problem here, Lordship. 23rd we have a problem. So 27, 28th any day. 28th. 29th maybe.
No, 23rd is the same matter.
23rd,
no, the other appeal.
The other appeal.
Arising out of the same award when Mr. Nongri is appealing.
Okay.
Same, Nahai has preferred it, arising out of the same award.
But not connected with Madam's case.
No, the issue is the same.
The
basic
issue.
Contention is that again section 19 has not been properly complied, the award has not been attached, so therefore the entire reference is valid. Same issue has been raised.
But as far as you are concerned, you are not in that case.
I'm not in that case.
No, not in this case. The award is the same.
Okay.
The award is the same.
Now I recall.
That case is already admitted. We are on paper book, Lordship.
Okay.
27th, Lordship.
Okay, we'll. No, if this matter is fixed on 23rd along with the other case, then we'll. From there on, it'll have to be another 1 week or 2 weeks.
So 27 times.
27 will be too early. We'll fix it on 3rd then.
3rd of November, Lordship.
Tentatively.
On that day, Lordship, endeavour to finish it, Lordship. It's been dragging for so long.
Exactly.
It's unnecessary, it's dragging. And today it's admission and I don't know, Lordship. And either the counsel cannot come, or the counsel is outside scared to enter the court. I don't know what is happening.
On Miss P, the counsel for the appellant has sought for some time to be prepared in this matter. Accordingly, as prayed for, this matter on 23rd. That's the other one is number
FA1. FA2 also.
FA1 is not before your lordship.
FA2.
Item number 1 and 3.
yes. Item 3 will fix it on 3rd.
On 3rd. 1 also on 3rd, lordship, both.
No. 1 will be on 23rd.
Okay.
And 2 will be on. Oh, but you are also here and.
I'm in 1.
Okay. Then how do we reconcile the other case with this?
I will just say 23rd, the other case, the issue is the same. It will be easier for lordships to decide both the issues together. Same subject matter.
So let's appeal.
Exactly. So 23rd, the other appeal is there. Their appeal against the other party. Same issue, section 19. If that is resolved, then 3rd, only your matter remains.
But that she says is admitted.
Correct. So it can be heard and disposed of together. Either on the at admission stage, it may be dismissed, if at all.
But I'll be prejudiced, no?
Their appeal may be dismissed.
If it's allowed, I'll be prejudiced. I mean, you can't presume. I'll be prejudiced.
Okay, this is matter on 3rd. Then we may have to adjourn the other case to 3rd.
In case 23rd, my lords, find that that appeal is not maintainable, that will act as a precedent for the 3rd.
So let me take advantage of both laws.
Okay. This is matter on 3rd.
Item number 2.
Lordship, in this appeal, I have sent the notice by post. So the report is awaiting. We are looking for a postal certificate. So I'll file the affidavit, Your Lordship. Service affidavit.
Mr. Nai Chaudhary, Land Counsel for the appellant has sought for some more time to file the affidavit of service. Upon confirmation of service of the said notice issued upon the respondents. How many respondents are there?
3.
3 respondents. As prayed for, this is matter after 2 weeks.
Hello.
Item number 5.
On hearing.
No, I don't understand.
5 and 6 I am for the petitioner.
5, 6, 7 are connected.
We have challenged the appointment of private respondent. Our cases were they are not eligible to be appointed, my lord. They did not fulfill the advertisement criteria for appointment as teachers, and they have been appointed.
School matter?
School matter.
You are in 7. You are in 5 and 6.
5 and 6.
So 5, 6, 7 are all connected.
Yes, sir.
Concerned the same school.
Same school.
So we'll take it up after break. Already we have crossed our lunch time.
Yes,
Yes, ma'am. Subject to seniors concern.
We'll have happen 4th, Your Lordship. 4th November.
My lord is talking about 4 o'clock.
Do we have such a long break? I don't. I've never heard of a lunch break which extend from now till 4th.
Oh, sorry. I mean the matters, Your Lordship. Take on some other day, Your Lordship. On 4th will do.
It's too far.
Too far? Issues the date,
Next week, if it's accommodated, it can be accommodated next week or maybe 10 days.
We'll have it on 27th.
27.
Yes.
Connected. So
Item.
5, 6, 7, 8 all connected.
Connected.
Here what happened with 5 and 6, we have challenged the appointment, my lord.
It's have been item 8.
Number 7 is the petitioner whose appointment we have challenged, my lord.
Okay.
She has come for payment of salary or something.
But her appointment is under challenge in item number 6.
Okay.
Appointment of petitioners is item number 8 is under challenge in item number 6.
And have to carry your lordship on 27.
We'll have it. As prayed for by the parties, this matter on 27.
On 27. Obliged.
3 years they are continuing, my lord, in spite of challenge. Not eligible, my lord.
Item number 12.
Obliged.
May it please, Lordship, this was the matter regarding recognition of the teacher. On the last occasion, Lordship, it was partly heard, we had started, but in the course of the hearing, it was noticed, Lordship, that the counsel for the managing committee was unavailable, and we had appraised that she is suffered a stroke.
Oh, that
Lordship.
yes.
So I believe today also she is not
Then
here.
should you take issue fresh notice?
Lordship, I had actually spoken to her over phone. She said that she'll be recovering and she is desirous of appearing.
Oh.
So I told her that to just contact with her client and inform when they want to engage a different counsel. But I have not been informed anything as of today, Lordship. At this stage,
we'll take it up after 2 weeks. On payment by the parties, this is matter after 2 weeks.
Much obliged, Lordship.
Obliged.